Yes. Okay. Others are just joining. So let's give them maybe like 2 minutes and then we can start.
Good afternoon, Madam Ajuma.
Good afternoon. So, hi everyone, and welcome to this afternoon session. Good to see you, and congrats to those who crossed over from the mental idea review session. So most of you scored above 2, and for those who were borderline, borderline 3, we issued you epic sprints and we've reviewed the epic sprints. So keep the work, keep up with the work. That's all I can say. There's still a lot more to do. And we'll still be issuing those epic sprints to some of you that have weak work in some areas. However, well done for the job done so far. So today's session is the legal session. And the goal of the session is to help you set up your company and legal framework. Some have set up companies already, but is it properly set up? You know, do you have the right legal framework? So the mentors, partners, legal partners are going to speak to that this afternoon. I see they are already in the room. So it's mandatory that every founder going through this program has a company incorporated. We back incorporated, we back companies and not individuals. And so if you're not yet ready to incorporate, you must have received the emails about the deadline. If you're not ready to incorporate, the company will ask you to, will have to let you off the program and re-enroll later, in a future cohort when you're, ready to incorporate or do business the way that we're setting you up to do properly. And the mentors are going to speak in, on the following, areas. Why is it important to have a legal entity? The best practices in setting up a legal entity, how to pick a law firm to work with, how to effectively manage your law firm. That's manage your relationship with the law firm that you've chosen. And then what are the key legal concepts that the founder needs to understand? And then key agreements that you need to operate for a technology company. Also, how do you identify and protect your intellectual property? How much, how do you manage, how to manage regulations, and how much the law actually means to your business. So those are the discussions we're, going to have this afternoon. And so join me in welcoming our legal partners, Matrix Solicitors. And we are honored to have the managing partner who is, with us today. He's in the person of Mr. Bayo Omole, who is the managing partner of Matrix Solicitors LLP, a thriving legal practice with offices in Lagos and Abuja, and has over 18 years or more of legal career advising multinationals, national entities, and individuals. So we're honored to have him here. It's not easy to hire such a firm. They have major big clients, and his skills include corporate law, corporate finance, commercial litigation, arbitration, dispute resolution, contract negotiation, intellectual property. He's an alumni of the Columbia Law School with an LLM there, Nigerian Law School, University of Ibadan LLB, and also Harvard Law School. Also on the team, he has brought his team with him here, Nafisat Ali, who is associate at Matrix Solicitors, who also has skills in mergers and acquisitions, corporate law, corporate tax, and private equity. Also with certifications from the Nigerian Law School, University of Benin, and a whole range of certifications that she has in her portfolio. Also from Matrix Solicitors is Olupeju Kolajo, who is also an attorney on the team, with certifications from Said Business School, and many more. Their links will be shared. Her skills include negotiation, team building, legal research, corporate law, commercial litigation. And so, like I always drum it up, the lawyers you need to the right kind of lawyer to advise your business are those who are versed in corporate law, corporate finance, commercial law, not the charge and bill lawyers or lawyers that specialize in other sectors or property law. These are the kind of lawyers you need to advise you properly when building a tech company. Also joining us is Freddie Atagana, who you all know as well, who is a systems engineer, data analyst, once an alumni or currently an alumni, now mentor, 2020 grad of Founder Institute, Zurich, who has been, very resourceful. Twice a founder, raised funding, and so he's also joining here, to bring in the perspective of how he has been through this route of setting up his company, the right agreements and equity collective and all of that. So that's the team we have today, and you're most welcome. We're delighted to have you, mentors, and we're all ears because I know that a lot of founders, do have questions about, legal issues and all. And so mentors are here to help you. So I encourage you to pay attention, and also all questions that you have, just have them ready. Today, we're not having a hot seat pitch, none of that today, but we have some reports to make, and I'll hand over to Mr. Shegun now to handle the rest of the program activity. Well, please, we'd like you to turn on your videos as well.
Okay, thank you. Thank you, Lydia. Thank you, guys. So Lydia has mentioned that we will not be having the pitch session today. There's a lot of things about legal issues, which the Founder Institute knows that you really need clarifications on. So today it's all about questions. I know a couple of you have had office hours with me and you threw those legal questions at me and I said, no, push them till the legal and equity. This is that time now. But first we'll have working group reports based on your old working group, right? The new working group will start. No, that's effective tomorrow, that is. So let's have our reports quickly, so we quickly begin to get our questions answered. Yes, who's going first? Who wants to go first? Should we start with Purple?
Hi, good afternoon, sir.
Afternoon.
Okay.
How are you?
Yeah, so for our last work group meeting, there were a lot of discussions, and the major success was at least 2 out of 3 of us was able to progress without an epic sprint, and that was a good success on our part. And also the difficulty in understanding the CDS part of the agreement was the major challenge for everyone, and I'm not sure any of us have resolved that till now. But otherwise, I think everything is going well. So that's my report. Thank you.
Okay, thank you. Let's go on to the Magenta guys.
Hi, everyone. Good afternoon. For Magenta, 4 of us are left in the group, and 3 of us had the epic sprint. So majority of the discussions was revolved around how to go past that. Those that had it shared their presentations, and we went back and forth to go through it and see how we can be in a good place. And we also had a little discussion about our financials. And I'm hoping that we can settle some of those problems on the call today. Thank you.
Okay. Okay, next. Blue. Are they all gone? Blue, Abdul Jabbar?
They're not present, sir. So Paul
Okay.
dropped out. Then the other 2
okay.
are not present.
I guess we have similar apples in the same basket. Okay, White.
Good afternoon, everyone.
Afternoon.
Yes, so for White working group, we had a lot of interactions going on in the group chat, and we also had our normal calls also during the week. and we're able to resolve a lot of issues related to the deliverables. And so far, I think we've cleared everything on our desk, all 3 members, and I think we're good to go. Thank you.
Okay. And then the green guys.
Good afternoon, everyone.
Good afternoon.
For the green team, we met Friday and we had several discussions in chat. We basically discussed the review from the MIR and then the task for the week. Please did our in order than everything went well. Thank you.
Okay. So quickly, without wasting time, we've seen all about the mentors and everything. So please start getting your questions ready. I don't know if Mr. Bayo, presentation or something for them before we kickstart.
Thank you. Good morning, good afternoon, everyone. I believe we're all in the time zone of Nigeria. It's nice to, I've met some of you personally, well, virtually, but it's good to have the opportunity to speak to everyone at once. And we're going to be talking about what has been pushed up on the screen, essentially legal guidance for your effort. There's a whole lot of effort going into what you're trying to do now. And if you put it within the proper structure and situated within the proper framework, then you will probably not have, it will be easier or have less bottlenecks when you're trying to scale, raise money, and you have less run-ins. You'll have no run-ins with the government, and then you'll be able to protect yourselves. So can we move quickly through these slides, because I think we may benefit more from the questions and answer, the Q&A session. So I've got my colleagues, as mentioned earlier, on the call, so I'll probably just ask any of them to chip in at any point in time in terms of answering your questions at the end. But if you have questions, 2 ways to go about it is as it's going on, you can be typing your questions into the chat box so we can save time. And of course, you can also, if it's too long or you want to tell some history, then you can wait till the end to, vocalize your question. So starting with an idea can make money, right? But can only make money in your head. You can make money in your head, but you can't spend that money publicly. You can even spend the money in your head. But if you are going to spend that money to buy anything, then you must actually earn that cash or have it transferred into your account. How do you then transact? Because you as an individual, you're a transaction vehicle. Your idea is a concept that's meant to bring, that's supposed to be filling needs, right? Filling a need or needs for which people will pay. Your idea encapsulates everything, all your effort. Whatever it is, you put it into something you can call the MVP that you're selling to whoever. It could be one person, it could be the public. But what you are hoping to get in return is payment for your work. And your work, of course, is ongoing. So is it better to do that as an individual, as a Mr. Bayo, going from person to person, or for you to put that idea, encapsulate everything into a vehicle? As an individual, it means you can go to this person, borrow money to set up your idea, to put your idea into reality. And if that idea does well, then you start to make money as yourself. But if as you're scaling, if you need to get more money, and some people give you money or you get money from anybody, and then it doesn't do so well, if they come after you, then it will be impossible to tell them, oh, no, this part of this car, I got it from the money you gave me. This other car, no, I got that one from somebody else's money, from another business I was doing. Why? Because it's just you. That's why you have to put your business into a corporate entity. A corporate entity is totally different from you. You are not the corporate entity. If you do well as an individual, the corporate entity may not be doing well by itself, even though there's a likelihood that if you do well as an individual, the corporate entity will do well. But if the corporate entity does well, you will also do well. But if the corporate entity has a liability, if it has a problem, you are insulated from the problems of the corporate entity. And then you're able to live your best life doing other things, can set up another entity and move on. So basically, the law sees you as an individual, the law sees the corporate entity as another, entity entirely. You are what we call corporation soul, and this one is corporation aggregate. Anyway, so setting up an entity is, of course, I've got 6 whatever here. A private company limited by shares, which is typically what is most advisable, is the type that, it's for profit, it's got shareholders, those of you that have co-founders. Of course, before 2020, you couldn't have less than 1 shareholder in a company. But now you can have only a sole shareholder, provided it's what you call a small company, where the turnover is less than 100 million or thereabouts. 100 million naira. But I'm hoping that all of you are anticipatory of turnover that is higher than 100 million. So it's always best to think of having more than 1 shareholder, right? And to structure that, some of you have seen in the past, and even in government, and really more visible, because of sensitive positions you hold, you can actually go into some sort of structure that sort of shields you from public glare, but you will still have an interest in the company. But even if you're in public, if you're a public servant, you can be a shareholder, but not a director, right? But you can always appoint somebody as a director. There are people who we refer to as shadow directors, who are on the board of your company, but do what you ask them to do, but you are not seen on the board. So, I mean, I'm just saying this. I don't know the profile of all of you. I don't know if any of you is a government worker or somebody who's a politically exposed person. So, yeah, that's why I just thought to chip that in. But essentially, a private limited by share, a private company limited by shares is one in which you have your shares are private. It can't be traded publicly. It can't be traded on the stock exchange. Before any shareholder can come in, you must get everybody's buy-in in the company. So that's one. And of course, what I would suggest, the decent minimum share capital, I would say, is 1 million naira. It doesn't mean you need 1 million naira to set it up, right? It's just that what you're telling the world that you can raise publicly, from shares, is 1 million naira. Now, that 1 million naira doesn't necessarily, of course, that's nominal share capital. It can be at premium, it can be at a discount, but you have 1 million naira you have 1 million shares at a nominal value of ₦1 each. But what you pay for setting it up is maybe like 100,000 or something like that. So a limited partnership is what you see many private equity firms take on. Yeah, or yeah. So basically you have a general partner and a limited partner, and it has to do with the liability. Now, liability means when in your company, for instance, if the company doesn't do well and it has to be wound up, your liability is limited to the unpaid part of your equity. So for instance, you have a 1 million naira share capital entity. You have paid up 800,000, you have 200,000 unpaid. If the company doesn't do well and you have to wind it up, your capital is limited, your liability rather is limited to that 200,000. Obviously, that's barring other debts other things that you can realize to pay all your creditors. But it's safe because it protects, like I said, it protects you from personal liability. And then it's a structure recognized by most businesses that will fund you. Nobody will fund anybody as a person. But people are more inclined to funding corporate entities. So your limited partnership is one in which there's a general partner, there's a limited partner. But I would imagine that most of the businesses that will require that you guys are doing will be more suited for the private company limited by shares. Because when you have partnerships that typically they relate largely to, well, I mean, any of these structures, as you read them, they are applicable. You can use them, but they are more suited for like consultancy firms, like the partnerships, consultancy firms, and maybe funding organizations like, private equity firms, and it depends on the amount of liability you want to take on. A public company obviously is not for discussion at this time because it has to be listed on the stock exchange, and the shares can be traded on the stock exchange. Take Nigerian Breweries PLC. You can go. You don't even need to know the people that started it. It's not important. You can just go to your stockbroker and buy, or First Bank or Guarantee Trust Bank can buy. Sorry, GT Bank or Zenith Bank or UBA. Buy their shares. MTN, you can buy their shares while you are here. It's so interesting that even foreign shares now you can buy from your seat on your desk in Nigeria. So unlimited company means there is no limitation of liabilities, right? It means that if your liabilities, if the liability of the company is 1 billion or $1 billion, it means all the members will be responsible. There's no, yes, it's a company, but there's no cap to that. Typically, I hardly see any unlimited companies now. The companies in which we used to see some unlimited removal of cap before was where some oil companies in Nigeria, some IOCs, some international oil companies in Nigeria, where they had unlimited liability for their whatever. But now most of them have even converted, to limited companies, or they've listed. So sole proprietorship is just you, Bayo and Sons, but that is not applicable in this case. Next slide. Who's pushing these slides? It's not me. Who's pushing these slides? Right. Regulatory framework. All of you fit into some sort of tech or some sort, whatever it is, really. It doesn't even have to be tech. You're a startup, you're a startup. It simply means somebody has struggled, somebody has an idea, wants to put it in something, and has started to maybe develop an app for it and wants to get people to do it as SAS or SAS or whatever it is, all of it must be regulated, because without regulation, there will be abuse. Even you are at risk. Your idea is at high risk without regulation. So as you can see, we've tried to categorize. There are more, technology. Before now, tech was just technology, was TMT, technology, media, telecommunications, media, and technology was just, but as technology, evolved, we started to subcategorize. So you have education technology. That's where you have people like ULesson, you have Udemy, but Udemy is not Nigeria, of course. You have Udemy, you have Educoya, Old School. You have insurance tech. You have agricultural technology. You have fintech, which is what most of us are familiar with. You have e-commerce. You have health tech. Of course, there's property tech, which is not here. I know one or two of you are doing that. But any form of technology you do, there's, in fact, legal tech. There's legal tech, right? Very soon, there's going to be church tech. Or, I'm expecting that very soon, or mosque tech or something, but hey. So, well, those are not for profit, hopefully. Yeah. But I'm just saying that anything you can conceive of that money can be made from in human endeavor now will have a tech component. And this is a huge part now, because from 2026, 25, AI is going mainstream. Already we know AI is coming mainstream on a very aggressive scale. Of course, before now, WhatsApp didn't have AI integrated into it, but now it does. Zoom that we're using right now didn't have AI integrated into it, but now it does. All of that is the evolution of technology, which will eventually take over everything until the world explodes someday and everything just ends. I'm thinking, I don't know, but until then, we keep making money from technology. So, so there's health tech, but all these are the regulators, right? You can't just start something and, I asked some of you, which regulators are you talking to? Which, have you registered with this? Have you registered with that? Some of you, apart from even registering with technology, whatever, you need to look at the professional, whatever is governing that particular practice, or that area. But then again, all of that is whatever. So next, if you have questions on this, feel free to ask. Regulators are government, government established agencies, right? That without them, you can't even do stuff. They issue permits or, permits, basically, operating, whatever. They permit you to set up what you're doing, to go out there and make money. Without that, if they clamp down, that's it. I know there are a whole lot of fintech companies, these lending apps. There are those that are regulated. That's the regulator, right? There are those that are licensed. Unfortunately, you have many that are all over the place, rogue lending apps that are just harassing everybody all over the place, and for those, the police has created a desk, they just lend people money anyhow and harass them to their death. They're not, those ones are not registered, they're not licensed, they just operate from one room, which is not a problem, but just do the right thing, be registered. Now, when you set up your entity, of course, thinking about the companies, the private company method by shares, you must have directors, you have shareholders, you have, an address, and then that is the entity recognized by government, by the whole world that you can transact with, and in whom anybody will invest, but because starting up really is not particularly easy, the government made an attempt to make it easy, provide some soft landing for startups, right? That's why the Startup Act came on, right? And the Startup Act is supposed to have some sort of fund, right? Which is supposed to be managed by the NSI. NSI is Nigerian Sovereign Investment Authority. And in fact, to qualify you can get from the fund if you qualify. And the first qualification is that you're actually incorporated as a company, right? And then you meet certain criteria. Can you move this, please? Can you move the slide? Next slide, So no, not that one. Previous one, still on the Startup Act. Yes. So you're supposed to be able to benefit from the government, incentives. There are some incentives that are not here, but essentially the Startup Act, knowing that you are just starting, is supposed to guarantee training and capacity building for startups through meaningful partnerships. Now, I know that NITA, for instance, has a small office, not under the Startup Act, that helps AI and robotics. They actually train and build capacity there. I think it's called, forgotten what it's called, somewhere in Abuja. Yeah, but they actually do that there. The government wants to give you tax incentives. You start up, you've only been investing. Most of you are bootstrapping. Those of you that are not bootstrapping have some small investment right now. It doesn't make sense that you pay everything, even if you start making little money. Government doesn't think the right thing is to start paying taxes. So there's tax relief. Pioneer status, if what you're doing is is very new, and but pioneer status really for startups is you can almost get it as a matter of course under the Startup Act when it comes into force, when it becomes very effective. So yeah, all these incentives, support with regulators, they will help you with all. If you are moving money outside, no tap remittances. If you get technology from outside and you need to pay what you call invisible payments, then no tap will help you with that. Support with all the agencies, trademarks, copyright commission, if you're writing software, access to grants, and all of this. Now, the Startup Act itself, next slide, hasn't become really effective, unfortunately, because there was a lot of impetus under the Buhari government, which sadly kind of slowed down towards the end because, I don't know, maybe campaigns kind of took over. But I think we're looking to really get back into it now to ensure that it's not just a dormant or a latent act, but it achieves its potential. So we're actually getting back into it to actually begin to push people that it's either you repeal this thing so we know it doesn't exist, or we get it done, right? Because we're a firm believer that unemployment rates being very high is because many people are not taking the steps you guys have taken, which is to try and become entrepreneurs. And entrepreneurship requires government support. And government support is not by distributing cash, to you. It's about a structured, support for startups, for those entrepreneurs who have taken the gauntlet, taken up the gauntlet to actually launch out. When you, in a structured fashion, support their businesses, then that is when the government can see the upside of this in another 5 years. And because each business that is nurtured will employ people and spring into other sub-businesses, there'll be spin-offs. So that's why we are quite passionate about that Startup Act being implemented. And I'm hoping that by the next cohort, or before the end of this cohort, we'll have something decent to report with our effort with government in ensuring that. Equity finance. So talking about financing, yes, you set up, most of you, like I said, are bootstrapping. But yeah, at some point you need to look for money. When you have shares are actually money, right? Because if somebody wants to invest in your company, what do you give back? You don't give your liver, you give shares in the company, right? So that's equity financing. Somebody says, I want this. So, but what do you need to look out for? What do you need to be before somebody can actually decide that, look, I think we should invest in you. You know, we should buy into your company. Now, equity finance is different from debt financing because in equity financing, if everything goes well, we all enjoy the upside. If everything goes south, we shake our hands and everybody goes away, right? So I invest in you. I invest in your company. If you do well, then I make a percentage of your profits, right? If you don't do well, I go away. I lose my investment. In debt financing, it's totally different. Debt financing, whether or not you do well, I'll get my money back. So typically, you have to securitize it, you have to collateralize it with something, right? That's why some people put down house, some put down whatever, right? But it can be all sorts of, you know, equipment lease, equipment finance, equipment this. Government grants and subsidies shouldn't be under debt, right? Yeah, government grants and subsidies, that's an error here. When there's a grant, except of course, you know, like this NEL fund that government is doing, lending students money. There are times that government lends businesses money at a very, okay, so it should be there, you're right. So it's sort of grant, but assuming the commercial rate is 26% and government gives you a single digit loan under the CBN, and that happened a lot under the agriculture, whatever. We're giving loans at, you know, single digits of 8% or 9%, while commercial loans were 20-something%. What that means is if you take that money as a startup, you're able to scale faster than somebody who has gone to Access Bank, right, or a GT Bank. And the other sort of other financing. Mezzanine is both. You know, it's midway, it's like a hybrid. You know, you can have a loan that converts to equity, right? A debt that converts to equity. If, you know, somebody lends you money and at the time you're supposed to pay back, you're not able to pay back, the person can say, okay, I'll take 30% of the company, which again is it's still good because your company is not you. Like I always said, your company is not you. And I always say something to startups, not even startups alone, but people who require financing. If you keep 100% of zero, it remains zero. But if you have somebody who wants to bring you money and wants 10% of your company or 5% or even 10%, but you're insisting on, no, it's too much. Like I only give you 2% equity. I hope you know that that 98% you have until it becomes something is still nothing. It's still 98% of zero, you know? So actually, you are the one that should look at yourself. What can I do with the money that this person is bringing? What can I turn it into? Can I use it to scale in a way that this 10% this person is asking for, this 5% is nothing, right? Can I scale in a way that, you know, in fact, or do I want to remain on the same spot? We've seen people that keep perambulating, looking for people that want 2% or 1%, you know, for significant money. So it's on you to decide what you want to do with the money. And of course, by all means, the less you can get the person to take for financing, the better for you, provided the person doesn't walk away, right? And you have your agreement in place. Next slide. I think I'll rush through the rest. Taxes you will pay, but not now. Next slide. If you're a startup, I will encourage, I mean, I'm very keen on people pushing for pioneer status, but that's why the Startup Act needs to come into force quickly. I mean, effectiveness quickly so that, you know, whatever. But when you start running the company, normally when you start declaring what? Profits. Once you set up your company, you must register with FIRS. FRS is Federal Inland Revenue Service. And even if you're not making any profit, every month you must file something called nil-nil, right? Nil-nil returns, meaning, look, I've not made any profit. So but on VAT, on CIT is company's income tax, right? On CIT, on VAT, you file your nil-nil, because if you don't, a penalty accrues every month. For every month you are in default, right? So, but I think there's a window, but I mean, all of that is in detail, right? But yeah, you register with FRS. In some cases, you need to register with SCUMO. SCUMO is EFCC, Special Control Against Money Laundering or something like that, right? You have to register with those so they don't stress you. Yeah, and that's that. The taxes you need to also be aware of when you start to work, when you start to be productive. Next slide. Tell you about all of this, of course, contributions, indirect taxes, VAT, stamp duties, custom duties on whatever. All of that are kind of integrated, depending on exactly what you do, right? But many of them are integrated into, even at the end of the day, if you ask me, taxes are passed largely to, yes, it's a company tax, but it's on profit, right? Stamp duties are on any transaction you do. So it's not like anybody just come and slam you with taxes without any warning. Next slide. Yeah, intellectual property is important because everything we're doing here is from idea. What are we, I mean, the idea moves into something you have done. How do you protect all your ideas? How do you protect what you are selling? You've got copyright, patent, trademark, secrets, industrial design. All of you will fall into at least 2 or 3 categories here. At least 2, as I see it. At least you fall in trademarks, you fall on, I mean, if you have a logo, that you use to identify or distinguish your brand, then you probably need to register that with the with the Trademarks Registry. Same with the patent. If you have a new idea, some sort of invention that you think hasn't been done before, or it has been done before, but this time you've improved it so much that you want to register that patent for yourself, then you probably need to approach the Trademarks and Patent Office as well. Copyright is like the most straightforward. It's the most tricky of them, but it's the easiest to attach because copyright attaches by default. Once your work is original, like software, it's just original, and then you have to register. But you don't register it; it attaches automatically, but you have to go and notify the Nigerian Copyright Commission, for software. All these are basically, whatever. And why do I say this? If you register it, once you see that your brand is doing well, you're advised to go and register it. Why? Because someday your brand alone will be worth millions. Just the brand, right? I mean, there are brands now, Nike, Coca-Cola, just the logo, I think maybe $1 billion or something like that, So, I mean, I always told a story about when Vodacom was coming to Nigeria and some sharp guys had gone to register Vodacom in Nigeria. And by the time Vodacom arrived, they could not register it. And because it was already in existence here because some people had registered it. And some sharp Nigerian boys and they demanded some money. I can't remember how much they demanded, maybe $200,000 to release the trademark to them because that's what Vodacom is known by all over the world. And at the end of the day, they had to negotiate, right? I don't know what they paid those guys, maybe $30,000 or something, but they released the. But what did it cost those boys to register it? Maybe 10,000 naira or something like that, or 20,000 at that time. It's not anything serious. So yeah, that's the logo, because at that time, Vodacom did not imagine they were coming here. Today, you're doing something that you're hoping will become big. So protect it now. Next slide. Next. Yes, these are the reasons you should protect. Yeah, go back. These are the reasons you protect. Go back. Yeah, because your IP is an asset. People actually leverage IP, intellectual property. You know, you license it, you get money from it. That's why you can't just go and, you know, record a Davido song and start singing it somewhere as Davido. You know, you can't just, that's intellectual property violation, right? And it can be, you know, it's serious, violation, liability and damages for infringement is serious. And it's something that you can, if your brand is worth something decent, it's a major, it forms major part when you are being acquired or when you are acquiring people. I mean, in negotiations and mergers and acquisitions or stuff like that, you know, it becomes very useful. And, you know, it's meant to be protected because to prevent from exploitation, one, and then for your own maximization of the exploitation of it. Because for others to use it, you must give them permission to use it. So that's what this is about. Next. I think that's data protection, because most of you, especially technology entities, we didn't have this problem 10 years ago, you know, but as technology evolved and as it keeps evolving, there's a whole lot of data being collected about everybody. There was some news yesterday about some people that were arrested for selling people's data. You know, data, personal data includes everything about you as an individual. They've been selling it, you know, selling it and making money. They go and harvest it from places and sell it unlawfully. So they were all arrested earlier this week. I think it was Monday. That was in the news. So basically, the Nigerian, fortunately, there's a commission now, the Nigerian Data Protection Commission, that was set up, you know, by the government, that all data you collect as, you know, a startup. I mean, for a startup itself, you're supposed to register if you collect a certain number, if it's a certain threshold, if it goes above a certain threshold, right? And then you have what you call a data protection officer who is certified. And then every year you go through an audit, you know, you have a DPCO, which must be registered. And, you know, your DPCO is like somebody who externally monitors what you do, you know, to ensure that you are actually you're actually compliant with the Data Protection Act. And yeah, they conduct audits. So our firm is actually a DPCO as well. So, you know, you have to do that so as not to run foul of the law, because data protection is taken really seriously in Nigeria now. And for those of you that collect data, there are ways you can deal with it. It's not like you can't deal with it, but getting consent of the data subject, what we call data subjects, those are people that own the data, even you as an individual, you're a data subject, getting their consent at the point of, you know, if you're signing up to something online, you will see something about accepting all cookies. Well, most of us don't read those things. But once you accept those cookies, you have given your consent for how your data should be used. And that's why you can see that as you're checking glasses, frames for your glasses somewhere, you see somebody else reaching out to you saying, we have this type of glasses as well. It's AI plus data, it's all a whole lot of stuff, right? But did I permit you as a startup to use my data to give it to these people? That is a different ballgame entirely. So the use of data, you have to understand that very clearly, and how not to use data. I mean, how to use it and how not to use it, how to, you know, stay protected under that. So next slide. Yeah, rights of a data. I mean, the data subject can, you know, ask you to erase. You know, they can object, they can say, okay, I want to verify what you have. You know, I mean, the Act protects data subjects, right? But there are certain circumstances where the rights of data subjects are, you know, circumscribed by the law. For instance, in security situations, EFCC, DSS, the police can, you know, can get your data without your consent from a collector, right? So whether or not you give the consent, if they need it for those kind of purposes, they can get it. Next slide. Yes, so this are the basic kind of interactions you're going to have as a startup. Like setting up your company, your articles of association is what you are telling the world that, oh, well, your memorandum, which is not here, memorandum of association is what you're telling the world that you do, right? I.e., I am, you know, I'm setting up to be a bank, or I'm setting up to be an oil company, or I'm setting up to be this, I'm setting up to be, you know, a tech company, you know, or a construction company. That is your understanding of yourself, what you want the world to know that you do. All of this information will be checked, the memorandum of association and the articles of association. The public, the whole public can access it at CAC, so to speak. But the articles of association is actually your agreement with other people setting up the entity, that this is how we want to run this entity. This is how we want to set up this company. This is how we want to treat our shares. This is how we want to vote. This is how we want to, you know, appoint directors. Of course, the Companies and Other Matters Act, which is the governing act for companies, has a template of some sort, but you can, where allowed, contract out of it and say, oh, instead of quorum being 3, quorum, right, by the way, is, okay, number of people that must be at meetings before you take formal decisions. Instead of it being 2, we want 3 people. You know, you can contract out of that, you know. It's similar to what you call the founders agreement, right, or contracts, when you are more than one founder. If you have co-founders, then it will tell you, okay, what this person is bringing, what this person is doing, you know, how we intend to, the rights we have for, you know, what we're bringing to the table. If we have disputes, what are we going to do? How do we resolve it? Do we resolve it in a decent way or resolve it in a way that is going to scatter this whole thing? You know, that's all that is. That's between founders. It can even without having a company, you should have a founders agreement. Ordinarily, you can. But once you set up your company, then you might decide to have shareholders agreement. Why? Because the shareholders today might not be the shareholders in another 2 years, because when other people come in with equity, with money, and they want equity, equity means they become shareholders. So what do they become? They basically, on what basis are they coming on board? You have to express all of that in the shareholders agreement now, so that when they come on board, they either adhere to it, or, you know, you can tweak it when they come in. So shareholders agreement, next slide. You know, investment contracts, that's what we're talking about. Safe, simple agreement for future equity, right? You can get money today, right? It's not a loan, right? But it's money that you're putting in somebody's business, right? For equity, you know, at a particular, you know, when there's certain events certain trigger events that happen. So like I said, I told you before that mezzanine, they are like convertible notes, but they're not a debt. So they're actually recommended largely for startups, because a debt is heavy on a startup, right? A debt is heavy on a startup. So investment contracts, like I said, investments are also safe. You know, this person is bringing money. And in fact, a safe is actually a form of investment contract, right? So that's that. Joint venture or partnership agreements, you know, at times those are strategic agreements between you and some other people. This person can help me with this person can come in with this. You don't have to pay the person, right? But if we synergize, right? If we pull our resources together and we pull our synergies together, we can actually make money. And if we make money, this is how we're going to split it. So those sorts of arrangements also help startups. Next slide. Yes, because you probably at some point will have to employ people. It's good to make sure that your employment contracts are in place so that, you know, you don't have issues those of you that do use devs, I mean, these are with other stakeholders now. You have service level agreements, you have lease contracts if you're renting a place, confidentiality agreements, non-compete agreements. Now, or they could actually be clauses in some agreement, right? They don't have to be standalone agreements, all these agreements. I was telling some people about some startup that had this dev, those of you that have devs, and the guy was like the major dev, and the thing had actually almost hit MVP. And at a point, they just saw another product launch, right? And these partners came to me, these co-founders came to me and said, they saw a product that was launched, right? That was very similar to what they were developing. In fact, it was the same. And maybe it had a bit more, but, and it turns out it was their dev that went to launch that thing. So I asked for their agreement, the engagement agreement with him. They had none. They had none, So it was just a word of mouth thing. So the guy basically stole all the work he was doing for them, plus what he had learned from them, plus all their own ideas that they had exposed him to. He just stole everything and went to lunch. So that startup today, I think I'm not sure and it was just difficult at that point to begin to, it was just difficult. So, and they had put in a lot of money in that thing. So these are the reasons you need to protect yourself every step of the way from now, even from people that work with you, not because they are devils, but because human beings are human beings. You just need to protect yourself. That's it. Next. Yes, due diligence by founders. This is basically when you're doing equity, due diligence is always good, when you're setting out, due diligence, I'm sure they've taught you all of this, market research, all these things, all these just show your level of readiness to get into the market. And typically your funders will look at how well you've done all of this, right? Before investing in you. But if you are the one that is actually taking on from other people, that wants to kind of that wants to build your business on other people's model, on what other people have started, there's nothing wrong with that. You can build your model on what somebody else is already doing. That's some sort of small acquisition, right? These things you have to think about very critically. How is that thing doing? Past financial records, future projections, market analysis. Does the person understand the target market? Do you even understand the target market, industry trends of what you are building it on? You see, the same way this applies to you as somebody who will be funded. An investor is thinking of all of this about you. It's the same way you should be thinking about all of this about somebody else that you are collaborating with as a way of, maybe a takeover, like an acquisition of some sort, right? So this is just a general page to let you know that you have a duty to minimize risks. Whether you are the one being invested in, you must demonstrate that, look, I'm risk-free. I'm worthy of your investment. Or if you are the one investing in another, another startup as it were, another idea to start up your own. If you are taking on strategically another idea to create your own startup, you have to look at all of this. You have to analyze that idea with all these metrics and perhaps more, in making your business decision. Next. And I think that should be all. Yeah. So this is like a, bits and bobs here, but it would be good to have, I see like 15 questions. let's just start taking the questions one by one. I want to believe my people have started answering these questions, Seth. It's like nobody has.
Nobody has. So there are so many. In
There are
fact,
not many, there are just 15.
okay, you've grouped them. Okay. Because I was
They're not even
listing
up to
them out.
15.
1, 2, 3, 4, 5, 6,
Probably more.
11, 12, 13, 14. Oh, okay.
Okay, I think before the Q&A, we have Freddie here. Maybe he can also share perspective, right? In addition, right? Before Abby?
Actually, hi everyone. Actually, the session was quite rich. I think myself, I was reviewing some of the things we went through. I'll basically address the key parts I'd like to address is regarding first founders agreement. You need to have the right contracts with your software developers and all your collaborators, because I've been through the situation whereby you have a software developer, he comes in, you share the whole idea with him, you almost at the MVP stage, and then suddenly conflict starts. So he starts demanding money, or he is not willing to work as you guys had planned. So having the right agreement, especially with the team developing your technology and making sure that any IP, that's any intellectual property developed, is assigned to the company fully, is very, very important. You should not neglect that part. Make sure you have the right agreements in the technology. Secondly, the employees, the guys who are going to work for you on the team also, it's important to make sure that the company is properly structured. That's why we try to go for the private company with limited shares, because it allows you not just to have a proper structure in terms of your shareholders, your future investors, but also to deal with people legally. You cannot walk in the dark. That's why they say to go through Founder Institute, you need to incorporate your business, because they will be dealing with an organization. So have all the contracts in place, not just for the co-founders, but for any intern that's going to come in, any future employee, and make sure everything is transparent while you're walking through each of these steps, because your investors, your future investors, will want to see this when you go into the deal room. They want to see what are the agreements you've made with your co-founders, what are the agreements, what are the salaries you are paying your staff, and based on what value of work they're going to add to your startup. So co-founders, then your employees. To add something and maybe perhaps answer one of the questions in the chat, I saw somebody asking, like, at pre-seed stage, what is the right amount of equity to give and how does it work actually? So the preferred fundraising instrument legally at this point in stage for you, I believe, will be the shared agreement for future equity, because it allows an investor to put money in and agree to say, like, hey, listen, in 2 years, we are going to evaluate actually how much you've grown, and perhaps now convert the money I've invested into your startup in terms of shares. So there are standards in terms of interest rates that you have around in the space, in the startup space. I don't think it goes above, I think it's around 2 to 6%. I don't remember properly the number, but it's somewhere around there. So it allows you also not to give too much equity at the start, because at pre-seed, you cannot really say, this is what my idea is going to look like. This is actually how much is what. It's very difficult. You are generating zero revenue sometimes. Actually, you have zero revenues, because pre-seed means you just have an idea, you're still building your MVP, you're still finding your traction and your ground around the market. So go for the safe agreement at this stage, so that any angel investor, or if you are lucky VC, because there are very few VCs at the pre-seed stage, are going to be able to put money into your startup without you having the stress daily of, like, hey, listen, I've given 15% equity already out, I've given 20% equity. It allows you to just work gradually your way through. Each year, if you have an agreement for 1, 2, 3 years, after the 3 years, you're then going to have to sit with your investors and say, okay, you gave me, let's say, 50,000 USD. The 50,000 USD you gave me was for market research or for developing the MVP and finding my initial customers. You then evaluate and then say, okay, listen, you are going to get X amount of shares based on the new valuation cap of the company, because in the SAFE agreement, there is going to be a valuation cap. If in 5 years, your idea is going to be worth, let's say, 5 million USD, maybe the investor will say at the valuation cap on our SAFE agreement, my valuation cap will be 1.5 million USD. So at that, when you go now into valuation, he is going to have that advantage. That's why it's a win-win situation if everything goes well. And if things don't go well, we just shake hands and say, okay, we'll try next time again. So that's the plus side of going for the SAFE agreement. It protects you yourself as a startup, because debt can be crazy. So avoid to go for the debt, always go for the SAFE agreement. That will allow you to move very simply and raise funding without having too much stress and less legal work to go through. But for that to happen, make sure all the agreements with founders, employees, and even yourself within the company has been set up properly, and the deal room is going to be clean. So I think that's what I can add, because the presentation was quite very rich. So yeah, that's from my perspective. Protect yourself, guys.
Okay, so we've got 15 questions. I don't think I need to say who asked questions. Okay, I see some still coming in. Okay, so Bayo, how do we do this? I know some of those questions are very similar. Do I read them out one after the other, and then we just?
I think some have even been answered by the presentation, but yeah, we can run through them again. I think my people have even started to answer. I imagine we started answering
questions. Some of them.
Yeah.
Okay, so maybe
let's just start reading. What are the
Okay, so first let me start with the first one. Said Chris Mammon. He wants to know what are the legal implications of having one co-founder registered as a director with a CAC while the other co-founders are not. That's on your board with a CAC. Your co-founders are not registered as directors. What's the implication of that?
Directors take the lead in providing policy direction for the company. You know, a company is just an inanimate object without the individuals that are directors. The company has shareholders, right? But directors in the company must take decisions, not day to day, but policy, lead. Okay, we want to go into this space. We want to go into that space. That's the work of directors. Now, if you have a co-founder, it is very unlikely that your co-founder will not want to be a director. It's very unlikely. But I mean, being a director can be removed, can resign, So if I understand the question well, I don't know if this company has been set up already. But it is definitely possible for one person to it's a matter of election. If two people are not, when I say election, I don't mean it in that way. I mean, one elects to be a director. Yes. People who are shareholders, right? Who choose not to be directors, right? They can even nominate somebody else to represent them on the board, But I don't know. There's a bit of context one will need to get in that circumstance. But clearly, I mean, there's nothing to it. There's no legal implication. It's an internal issue. It's when I say internal, I mean in the organization. It is in terms of regulatory compliance, it's okay. The government doesn't know who's a co-founder or who's not. They just want directors who the government can hold responsible for defaults in paying, filing annual returns or whatever, So the directors that answer questions It's the directors that are seen by the whole world if the company cooperates. If the company does something crazy and the government is looking for people, the government looks for the directors. Yeah.
Okay.
So,
okay. So
yeah,
also
we
he
don't
wants to know. So he wants to know this. I think Fred might even give some insight into this. Must a startup be a C Corp? Must be C Corp incorporated in Delaware to be fundable?
No. You can be based in Nigeria, South Africa, anywhere, as far as your setup is proper. Why we recommend a private company and with limited number of shares, so that it gives some transparency to the investor also. He can see there's going to be a board of directors, there are shareholders in place. And that's what I was saying, even like at this stage, if you're at the pre-seed stage, go for the shared agreement for future equity. So it does not matter where you are in the world, because if the organization is properly set up, you can attract funding from everywhere. For example, our angel investors are not from South Africa, they are from outside of Africa. So because we have the proper setup in place, we are able to attract funding from anywhere in the world.
Okay, thank you, sir. Mohammed wants to know, his first question is, what are the key terms and conditions we should be aware of when negotiating with potential investors to ensure we retain sufficient control and equity in our startup? I don't know what I would say key terms and conditions. Maybe I should put it this way. What are those things they need to know to ensure that they don't lose their company while talking to investors? Yeah.
that has been answered by one of my colleagues, right? I mean,
Okay.
you know,
Okay,
but
great.
let me just emphasize the kind of, you can actually categorize your shares. So founders try to protect themselves by, you know, founder shares are actually weightier, right? You can have classes of shares. So you can create classes in your shares. You can have preferential shares, you can have founders shares, you know, and founders shares can actually, you can include stipulations, right, that they cannot be diluted beneath certain whatever, and that in voting they will have weight, they'll have more weight, they'll carry more weight in voting. So that way, even if there are more people that come to invest, the founders will still have weighty votes. You know, you can imagine that one of your own votes can be 3 of every other, you know, shareholder. Yeah, thereabouts. So yeah, there's a way you can class your shares and structure it. And then of course, all this restriction on transfer, so that you're not diluted without your knowing, you know. So
Okay.
it's possible.
I just got that one today. So some shares can actually be weightier when it comes to voting. Oh, okay. I got that. Okay. So I see the team is already answering most of those questions. So I'll just try and just pick some of them. Intellectual property. What are the best ways to protect our intellectual properties internationally? What are those things, locally, what are those things startups need to do?
Well, essentially, right, you have to, so there are some protocols that, for instance, if you're registered in one country and that country is a signatory to that protocol, it applies in all those countries as well. So that is actually the main way it's done. However, it's advisable to also, in any country that you are setting up or you plan to, you know, of course, you don't know where your software will go, right? So you don't know if it's software, for instance, you don't know who's going to download it from which country, right? Like I'm in Nigeria now, I have apps of companies in the US on my phone, right? So clearly, whether I can now in Nigeria go and register a company like that, I'll need to check whether that whatever is subscribed to the WIPO convention. WIPO is what the intellectual property organization, you know, and with the WIPO, under the WIPO convention rather, I mean, all countries that are signatories to it, have some sort of sister protection, at least for the first a number of months, at least 6 months. But if you know you're going to be doing a lot of business in a particular country, you're advised to check whether the law allows you to register there after 6 months. But the first 6 months, if the country is a WIPO convention country, then you are protected for the first 6 months. And after the 6 months, you might need to register, depending on that country's law. I'm not sure. So it behoves you, if you know you're going to be doing a whole lot more in India than everywhere, then you might have a lawyer in India advise you on the use of your intellectual property in India. But you know that typically your first 6 months, if India is, signatory to the WIPO Convention, as Nigeria is, then you're protected for the first 6 months.
Okay, thank you. Okay, I see data protection question has been answered. Okay, Peace wants to know what steps should be taken regarding transfer of shares in case a co-founder is no longer interested in the startup. I want to presume that co-founder is a shareholder. So in case he's no longer interested, I don't know, Bayo, there was one of our, in the last cohort, one of them had this kind of challenge and I, told him to see you. So I don't know, probably did or did not. So what happens at that stage? It didn't. It dropped out anyway, so.
Yeah, so typically somebody who's not interested, there are two ways. You either relinquish or you buy him out. You buy him out, because at that stage, typically the entity is not doing well yet, right? It's not yet, in Nigerian parlance, it hasn't blown, because that's why he's leaving, right?
He's not interested.
If it has blown, even if he doesn't like the color of your face, he will stay on, right? He will just be collecting money. But because it hasn't blown and he's tired of this headache, so you can just offer him something. And at that point, it's very easy to negotiate, an exit strategy. It's very easy at that stage. So, yeah.
Fred, have you experienced that, directly or, with that kind of thing, co-founders who want to go and probably demanding or not demanding or something?
Yeah, I've been through that. So, but as I said, like we had the right agreement to say, hey, in case you don't want to work with us anymore, it's fine. Based on the stage of business, you are free to go and don't expect any shares or compensation because as he had blown, if he had blown, of course, he would stay. But since you could see like we were still struggling, we said, okay, it's fine. You can leave, and then we are going to find somebody else to cover the job you were doing or upskill ourselves to do the task you were covering. So yeah, just have the right agreement in place so that if somebody decides to leave and he is a shareholder, a co-founder of the company, it's easy for him to exit. So make sure it's in place. Look for the right lawyers to draft your co-founder agreements. That's what actually I should say. Like, look for the right lawyers to do that for you. Don't go and download something online and try to adjust it yourself. Consult the proper legal people to assist you with that.
Okay, thank you very much. So I hear that clearly. The right agreement. Guys, the right agreement can save you a whole lot. Okay, I see Duro Jaye's question has been answered. If you have a company of 1 billion, I think I see the response there. Chiyoma's question on data, do all tech companies, that's been answered. Okay, please advise on the appropriate share split between founder, employee, director, and investor. I don't know if there's an appropriate split of shares in case you want to give this. Any advice for them on how to guide themselves when diluting shares to, yes.
Let's hear Freddie's perspective from a practical point of view before I give the legal perspective.
Yeah. Basically, for me as a founder, I think generally it's based on the stage of business at which you are. People tend to give us founders, I think like from the experience of seeing the ecosystem, we are generally more inclined to give more shares to people when they come at that earlier stage. That means we've started the business together. We are two of us and we want to both share the responsibility in the startup. Yes, but now if I've started the business already, 1 year down the line, I've developed my traction, I've developed my MVP. When you are coming in as a co-founder, if I'm looking as a co-founder, for a co-founder, I'm not going to give him as much shares as if he had started the business with me. Also, regarding employees, generally we have what we call packages for the employees. You need to work for X amount of years for you now to say, okay, I'm going to maybe have this pool of shares for my staff that started the business with me. So it depends on the stage of the business. You don't want to be diluted too much at the beginning. If you are two of you guys, the ideal situation generally you see is maybe I'm the developer, you are the business mind. Let's go for 50-50 or 60-40. That's because you are two of you. You are starting the business together. But once the business has been started by one person and you are bringing people in, you need to make sure like, hey, listen, I'm not going to give too much to these guys because I've already done the groundwork. I've built already the foundations of the business. So they are just coming to add a specific value to your startup. And these shares also must be vested because they're going to come to you. You don't just give shares like that. No. He has to work for a certain number of years for him to claim these shares. So if he's going to come and ask for 6% equity, for example, 6% equity, he has to work this 6% equity over 5 years. You can vest those shares over 5 years. So that if after 2 or 3 years, he decides to leave the company, you are only going to be negotiating his exit from the number of years he's worked for the startup, not for the whole shares he was supposed to be entitled after working for 5 years. So I think that's how my perspective on it. So let's listen also to the legal perspective. What legally is the best way to go about it?
Yes, thank you, Freddie. That was good. But I just want to state for starters that shareholders, the initial shareholders are typically the founders. That's all. Any other person that is getting shares will be investors, right? Investors who are, of course, investors typically mean that it's not debt. It means they are putting in money for equity, right? Founders can typically or should typically split depending on, you know, how they rate themselves when they start. It should be 50-50, right? Or depending on number, I mean equally. But if it's not an equal, you know, rating for themselves, among themselves, they can agree, you know, 40-30-30, right? But if there are 3, whatever it is, but that is how it should be taken. And besides, companies are not, I mean, under Kama now, all shares must be allotted. So 100% must be allotted anyway. So gone are the days where we used to allot 60% and leave 40%, you know, we hive it, you know, for subsequent, you know, whatever. So now any future investor is going to take from your already allotted shares. So when somebody comes in and you say, oh, and it's 50-50, for instance, and the person is taking 10%, then you both agree to drop 5%. That's divestment. You both agree to relinquish 5% each so that that person can have 10%. So you then have, they are diluted to 45, 10, right? If the person is taking and that's how it is, right? So, but typically everybody gets, I mean, the founders, it doesn't matter if it's 80-20 for founders. When an investor comes in, depending on your shareholders agreement or your founders agreement, if people are coming in and you're going to be divesting pari passu, then if it's 10%, that means you're dropping 10% of your 80%, which is now 8%. This person too is dropping 10% of his 20%, which is 2%, to make that person's whatever. So it means you now have 18%, that person has 78%, right? And that person has his own 10%. or something like that, you know. So that's how it works for investors and founders. But those other two categories, the directors are not entitled to shares. Directors don't have any shares, right? Directors are people that shareholders appoint. So, but what happens most of the time is that the shareholders themselves are either the directors or they appoint they appoint the directors. So, Freddie, for instance, can be a shareholder in a company and decide to be a director of the company. That's perfectly allowed in law. But he can be a shareholder and decide that, you know what, I don't want to be a director. I want to, you know, appoint my cousin as a director who also understands this business. And let me even mention this. Directors, most of the time, should be people that have a commitment to the company. It's not just being a director for the name of answering the name director. It has to be somebody who understands your business, who's interested in your business, so that when they see business opportunities, they bring it to the board, they help you, that you're able, you know, it's not just because directors they're not remunerated by default. But when your company gets really big, then you have to start to remunerate directors, because it takes time to take care of the company, to actually sit at board meetings, to think through things for the board, to, you know, it's a whole lot, you know. But again, at the startup stage, forget all that excessive flowery stuff. You should be the director. You are nobody is more passionate about your business than you. You are the shareholder, you be the director. If you are two co-founders, be the shareholders, be the directors. If other people are coming in, then you can give them investment, you can give them shares. But investors typically ask for a slot on the board because they also want to see what's going on, you know, with the company. And that's their right. I mean, there are times that they may say, you know what, if there's what we call share qualification, if the share qualification standard is 10%, for instance, saying, okay, any shareholder that has less than 10%, I mean, for you to have a seat on the board, you must have at least 10%. That means anybody that has 9% cannot appoint a director, cannot nominate a director, right? But most investors will want a seat on the board to even put somebody there to say, you know what, please keep an eye on that company for me. You know, that's my whatever. But again, they may not. But you as directors have what we call fiduciary duties. Fiduciary duties are duties to the shareholders of loyalty. That, look, the way you will spend the money, the way you will direct the company will be utmost good faith, right? So directorship is not, and that's why when there's a problem, when there's a fraud in the company, the government comes for, when there's fraud in the company, the government comes for the directors, right? Because they assume that the directors know everything going on in the company. Do you get what I mean? So that's what it is. So for directors, there's no share, there's no shares for directors. There's no share, directors don't become shareholders. Shareholders become directors. Yeah, note that. Now, employees don't have shares, except you want to have what you call stock options for employees, right? But like you said, there's usually a vesting agreement. It can be 10 years, it can be 5, whatever it is. But at a startup stage, your employees are not stable. I won't lie to you. Your employees are neither here nor there at that stage. So, but again, if you want to do it as a startup, it's up to you. It's your directors that will determine that, whether they will, you know, they will, that they think that's the best for the company at that point. But if it is going to be like that, then it should go the way you have described, which is it's got to have a vesting schedule, i.e., if you work for 3 years or 5 years, you have so percent. If you have otherwise, you're entitled to your what? Salary, right? Salary, you cannot deprive an employee. But as a startup, if you start to butcher the shares as a startup, you'll be shocked that employees will tell you when investors come that, look, oh, they have earned this thing and they cannot divest. And it can become a little of a ruckus. That's as a startup. So I mean, my own thinking or what I've seen done is that people defer that thing until the company is a bit more viable and the employee structure is more stable. Like people are more stable, and then you can, then say, okay, you know what? Let's put in an employee stock scheme in place. So to run your whatever again, directors, no shares, founders, yes, investors, definitely. They have shares for their investment, and employees, the default answer is no, with the exception, that you can create that when your company is more stable.
Okay. Thank you, sir. I see the data question has been answered. I see some more questions coming in. I'll pick some more questions. There's a question from Abubakar Sani, and I just saw another question coming in from Balogo. It's the same structure about a parent company and a subsidiary company. You have a registered company, and then you have a product that was made, or carried out by the parent company. How do you advise them manage this structure vis-a-vis investors? Invest in the major company, or they set up a subsidiary company registered and then get investors to invest in that. Let me give a typical example here. Let me use the person who asked a question. His main company is Asataura, and he has a product called My Slate. So which one should he open for investment? Should he say invest in Asataura, who probably have potential of more such products coming in, or should he go and register My Slates as an entity, and then, because they've asked me this question and I said, wait till the legal session comes up and then ask that question, and you get the pros and the cons for that. So it's over to you, sir.
Somebody has answered that question.
Oh, okay. Okay, I think I wasn't catching that. Okay. So IP trademark, that has been answered. That has been answered.
You can come back and say no.
Data. Sir?
But he can come back and say it's not okay with it.
Okay. In case it's not okay, you can just come back and say you're not clear on that. Retention data has been answered. I think, Catherine, let me check. I think all questions have been answered. I extracted some of the questions, and
let me just help Abubakar. Let me just help Abubakar a little. GT Bank or your bank has okay, exactly. Oh, okay, good. They have so many products, right? If they were to register all their products as companies, then the taxes they will be paying will be unbelievable, right? And every company is a living entity until it is struck out by CAC. Every company, that's why when people grow older, at some point, they start to consolidate. They start to, take out some of the companies they had set up in their, early years when they had like 15, 16 companies, just doing all sorts of things. They start to what you call consolidate, just to focus on a few. So for every company, you can create what we call an SBU, a company for a special purpose vehicle, as it were, for every product. As my colleague has said, register it as register a trademark for it, and promote it as a product under this company. That way, you minimize. That's efficient way to do it. You minimize costs. You minimize corporate compliance, because, for instance, even starting with Corporate Affairs Commission alone, not to talk of all the other government entities, Corporate Affairs Commission alone, every year you must file your annual returns. You must file your annual returns. And to file annual returns for every company, right, costs you money, right? So if you have one company that has several products, you have to file only your annual returns for that company alone. But if you have one company for every product you have, then you'll be filing 5, 6, and that will be unwieldy. That's eating into your profit from day one. So I hope that Yeah, great. Thank you.
I think so. If I missed your question, okay, I see one. Can you clearly explain the advantages of share dilution as opposed to undiluted shares for startup investors?
Hello, sir.
Just your question has hold on.
Yes. Sorry, I was trying to raise up my hand, but I couldn't see the icon, so I had to just. So that was a very good answer, but the problem we have is that we have several products, and so some of us we don't have the money to build all these products at once, so we just share a specific idea on a particular product with the co-founders. So we felt like, okay, since you guys founded just um, let's say Research Gains, because my company is Tornado Tech, but I have a product called Research Gains. But since we founded Research Gains, you co-founders should only be co-founders of Research Gains. The other ideas is in my head to build other products that solve the issues of research. So how do I, because if I should give them a share in Tornado Tech, they tend to also have future opportunities in my other ideas, which happens to be my other products, which I will be building. So how do I handle that situation with co-founders? Thank you.
So if I understand you correctly, you have products that you don't want Research Gains to develop, but you are willing to license that product. You want to, in quote, sell it. You want other co-founders are interested in developing that product for their own gains, right?
Okay, not really. Okay, let me just say a typical example. I have a company that owns Coca-Cola, that owns Fanta, that owns Sprite, but the ideas I have with my co-founder was only for Coca-Cola.
Yes.
So, and I only want them to earn the money on Coca-Cola, as a share equity. But I have an idea for Fanta, Sprite, and all. So I believe if they should have a share in the parent company, they also have benefit for all other products I will be bringing to the table in the future. So that is the issue we have with that. Yeah.
I got you. So basically, you want to limit their participation.
Exactly.
To the product for which you brought them in the first place.
Exactly. Yes.
In that case, just do some sort of joint venture with them or some sort of collaborative agreement, because they themselves, either as individuals or as they might even have their own companies, right?
Yes.
But they are also, if they don't want, they are not, if they are meant to participate in the development of that product, then
yes,
you must do something that can, some sort of strategic collaborative arrangement. But
okay.
it has nothing to do, with another entity. So it will be Research Gains and them, right, on those products.
Yes.
Alone.
Yes.
Right. So there are ways to structure this, but it'll be interesting to get the details. Maybe we can talk after this.
Okay, thank you very much, sir.
Okay, Bayo, if you permit me, I want to look at that because I sort of like have this perspective to that. Now I have a product, and holders and all of that, and we've developed product A, and product A is in the market. Let's say I take it that product A is succeeding. Why would you, as a founder, not want to replicate the same team for another idea? I don't know. Maybe Freddie, help me out here. I see this as being overprotective. Oh, I've succeeded with Coke. I want to hide Fanta. I think founders should be more open with their ideas. Be able to bring in a team. If I know person 1, 2, 3, and we've succeeded in product A, why don't I just open them up and we come into a team and I say, okay, This is research gains. We're into developing product. These are the team. They are shareholders and directors in research gain. Well, yeah, let's begin to churn out products every year. Churn out products. You'll be in charge of EdTech. You'll be in charge of this. I think that structure will ensure that you grow faster than saying, okay, come and help me with Fanta. When you finish Fanta, don't disturb me. I want to go ahead and build Coke. You open yourself to risk. The risk that you go out there and get new set of co-founders, some of them can be very, very, very dubious. And when you already have a winning team, I don't know, that's my perspective. Legally, you can do anything. I mean, with Mr. Bayo, you can structure any agreement. But I'm saying this as a founder, thinking like a founder, I'm thinking, why would you want to do that? Freddie.
It's subjective. It's a choice.
Yeah.
Because now, example, the company is called Ekamu and we are developing Iwi. So the idea is that when you bring people on a bigger dream, like, hey, listen, yes, this is a big company. We are going to be software development. Our main focus right now is beauty tech. You start with a product in beauty tech, you build a relationship because also it's about building the right relationships with the right team. Once you have that right team, you just want to replicate that success throughout and through. So I think like just have one big organization, sell the whole big vision to them, let them know right now you're focused on research gains and build that relationship with that team because it's not easy to go every day and hire new co-founders, find new people that are going to be able to put the same energy, the sacrifice, the time that needs for you to be successful. It's very, very hard hiring the right people in your organization. So for me, as Segun is saying, like just get them to come in the big picture. Listen, guys, we are going to be working on developing products. Right now, we are focused on this product. If the team are able to build some kind of synergy with those guys, the people are going to develop that first product with, take them and keep working with them. It's going to be difficult having all these different legal setup and it can get confusing. I feel like that it can get confusing down the line and you don't know what's what anymore. I work maybe with John on research gains. Now I'm working on chain and I'm not working with John, but I only have Peter now that work on research gains. So it's going to be, it feels very complex. Just sell the whole dream, the whole vision of the business to them, because that's what even makes it attractive to investors. The investor is going to ask you, do you want me to invest in research gains only or the big picture, the big organization? So they will be more willing to invest in the bigger organization rather than just people, because they're investing into you, into your team, the team that is working on research gains. And tomorrow they don't want to feel like, hey, we invested in this whole business. This guy is only using this team of people who have been a big success for him to develop that, and then he's going to change. So be open to sharing, because it's not about how much equity you have in the startup, sometimes about what's the value of that equity. You also have to sometimes look at it from that perspective. Yes, you feel like, yeah, I'm the guy coming up with the ideas, I deserve this, and that. Yeah, have an open talk with them. Maybe you can have 70, 10, 10. I don't know how your guys, what's the agreement you guys are going to have with your co-founders, but be more open, because an investor don't want to invest in a product, he wants to invest into an organization. What is the organization developing this product? And if you want to say you're going to have research gains and you have that as a company and do all this kind of partnership, the investor comes and invests into that product, and tomorrow you're going to do something else, it doesn't come across proper. It's not going to come across proper for me. Like, look at it properly and make the sacrifice and decide to work with the right people on the whole organization, not just restrict them to one product.
So that's moral. That's moral advice they've given you.
Yeah, so that's moral. Sir, please give us the pro and the con.
This man must have a reason for wanting to keep it away, and I don't think he wants to disclose it here. So just keep him. Just leave him.
Should I do that, or just help us out, sir? Legally, what are the pros and what are the cons to registering one entity and keep churning out products, or registering as the products come out, you keep registering them as a company? What are the pros?
I've given you the cons. It's a whole lot of, it's not efficient. It's not efficient. It minimizes, it reduces. Then again, it depends on how what the product is. If it's a complete pivoting, like you're doing stuff for you're building technology, a technology company that does stuff for health, and then all of a sudden you want to pivot, right, into hotel management or property, and you want to keep distinct identities, and perhaps you require a different skill set for that second whatever, then you don't want to conflate things. You want to separate the people. Yes, you might still be the arrowhead, but you're going to source a different skill set. And you just want to, yes, you will have the teething issues, but you'll be advised again, there's some skill set that are the same anywhere, like your finance person. Your finance person here will know finance here. But, for hotel management, for instance, there are some skill set that the person in health management cannot, struggle with. So that way, of course, it's good to keep them in what you call SBUs, special business units. You can then eventually incorporate those business units, but, to reduce your overheads at the beginning, it's best to keep them in separate business units until they begin to thrive. And then, or the idea becomes a real solid one, becomes an MVP. It becomes something that really can become, you don't want to set up a company and start paying government money at the beginning and start, struggling, so you can keep it at a small unit until, it becomes something that becomes viable. When it's viable, let's set up an entity for it. But ultimately, if it's like Liver Brothers, or like, okay, Liver Brothers, I'm not sure anybody knows what that is anymore. So, but I mean, it's like, it's like, it's like, they have several Guinness. Guinness has all sorts of products,
Yeah.
And yeah. And banks, they have all sorts of products.
Okay.
Right.
I know this has been exciting. I'm going to close with this question, except anybody has. It says there, what does it take to work with your law firm?
Well, seriousness. I'm sure one or two of you will know that.
Plenty money.
When I said, no, it's not plenty money. When I said time, when we set time for office hours and they don't show up, I get really upset, because even this period now, you can see me checking my phones. There are a whole lot that we're doing, when it's time. So seriousness, your ideas, I mean, you're ready. And I must say, I mean, the people we've mentored so far that have been decent people. Yeah, even when they were a bit off at the beginning, we straightened them out. But in terms of money, you see, we also have a burden to reduce unemployment, right? So I mean, we help as much as we can, right? Just come serious. And like I say, show some skin in the game, right? Don't come and say, no, I don't have anything. In Nigeria, they will tell you, I want to go to school, but I have nothing. Or I want to buy a car, but I have nothing. I'm telling you, I mean, I get this kind of ridiculous request. I want to buy a car. I ask, how much do you have? Nothing, sir. Like, really? Buy the car. You have to show some skin in the game. So come serious, but for me, if you're serious, it's the incentive for us. It's the incentive, and then we can discuss all structures that can reduce your burden, right, as a startup, and then get you better equipped to thrive. So what does it take? The first thing I'll say is that your idea must be good. You must be ready and willing to just go through stuff, and and money shouldn't be the first thing. No, money is not the first thing for us. That's the truth. Yeah. No, I should rephrase that. Not for FI. In other, yes, if your idea, if your business is not bringing money, don't come. But for FI, money is not the first thing. The first thing is, how do we get your business to work? Or how can we support you to get your business to work? Yes, we can benefit in the upside. We can, there are ways to structure it. There are ways to structure it.
Okay. So, Lady A, if I leave these questions coming in, we'll probably be here till 9 p.m. So let me. I think we can effectively say the Q&A session is over. So
Yes.
office hours and all. Lady A.
All right.
Solomon,
This
you know,
has been
just take over.
a very, very interesting session. You know, and like you said, it would have gone on and on and on and on. And you people are getting free legal advice. True or false? Free legal advice. So imagine that you had to go to the law firm you will not get, as much as you've gotten today. So you know where to go to. The firm is Matrix Solicitors. Like I said, they are not small-time lawyers, but you heard the managing partner tell, this is about interest and, helping to build. We need startups, we need entrepreneurs, to create jobs, and it's important that they are well structured. So that is why we haven't gotten into partnership with just any kind of lawyer, and that's across board. That's the FI standard. Okay, so the kind of briefs matrix, just check them out. So they are not for startups, but because of the interests, okay, they have, in helping to grow economic development. Yes, but that is not to say that you need to incorporate your company and you don't have the money. Matrix will not pay that one for you. They all pay for your trademark or your copyright or your no. That's not, they are not an NGO. That's not what we're talking about. There are fees. In fact, regular, before you can engage them, there are fees you pay, consultation fees that you pay before you can even have access. So we have broken that barrier and we have given you the access. So the rest is up to you to do the needful. So that's the much I can say. But incorporation, proper legal framework, you are building global businesses. So you need to do it right, period. And you go to experts, who have handled such and can, give you quality advice. So that's the way we're channeling you. Charge and bill lawyer is not for this business you are building. It's not charge and bill lawyer, okay? It will not take you anywhere. Rather, when an investor comes up, interests are coming, they will sort of discourage you, or because of their lack of knowledge or expertise in the field of commercial law and corporate finance. So that's I don't think I need to say much more than I have said so far. So thank you so much, Matrix solicitors and team. We didn't get to see the other, well, they were answering from behind, Nafisa and Olu. Yeah, thank you so much. And Freddie, thank you, for bringing the founder's perspective as one that has, experienced it upfront. And our time is pretty much up. We didn't have time to talk about the Equity Collective, but Mr. Shagun, office hours, I guess. And also, yeah, okay, we can do more of it. The Equity Collective as well is sort of like a safe, okay? Because all of this training we're giving to you for 4 months, the value is what is worth, much more. And that's why what you have paid, we call an entrance fee. Okay, so we bring quality mentors to you, training, help you to package, help you to build this global brand. It's not the value is not $3.99. It's far more than that. And so, that's what that is all about. So thank you, everyone. And any further, no, I don't think we want any questions. We're all tired, right? We need to go and rest. And then we need to allow you to go and tackle your sprints for against next week. I'm sending out some epic sprints because I'm still seeing some work that is not weak in some areas. So pitching. Mm-hmm. So there are some slides that I don't like the look of the slides and even the way you're still pitching. And another session, another investor session is coming down the line very soon. And so, we need to make progress. So thank you, everyone. Yeah. So have a good rest of the day. It's 4:00 evening. Yeah.
Right.
So,
Ciao.
bye. Bye.
Yeah, bye.
Bye, everyone.
Bye, ma'am. Bye, everyone.
Bye.
Mhm.
Bye.